Wait, please, Lordship. Lordship, with the consent of other side, Lordship, I beg to mention item number 44, Lordship. In this case, we have to produce the record, Lordship. We have not received the record. After 4 weeks, Lordship.
44, who's for the other side?
Other side, Lordship, A. Tiwari is there, Lordship. I have already informed him.
44 on the request made by Mr. K. Gogoi.
Lordship.
Learned CDC.
Lordship.
Matter stands deferred to be listed after 4 weeks, enabling him to produce the relevant records.
Lordship.
Your name?
Gupta.
M.S.O. Gupta appears for the writ petition.
Lordship.
I beg to mention I am item for listing for tomorrow, my lord. So I am pressing an interim IA, my lord, for orders tomorrow. All right, sir.
Right. Lordship, I beg to mention item 42 and 43 of today's list. Lordship, here we have misplaced the file. I am informed the other side, Lordship. We need some time to reconstruct the file, Lordship. Any
I
day,
put a petition, my lord.
Ah.
My lord, maybe taken on 2nd of December, my lord.
any day, Lordship.
2nd of December, we don't know.
My lord,
Matter be listed again on the request made by Mr. H. Oliha, counsel for the petitioner, respondent.
Yes.
Matter stands deferred to be listed in the month of January. It will go to.
my lord, we have some urgency, my lord.
You have urgency. Why have you mentioned it? Why have you agreed to the adjournment?
My lord, they have no.
Don't have. It's good for
The
you.
second
to
week
get a
of-
walkover.
2nd week of December, my lord.
Not 2nd week of December.
First week of-
It can't be. Will be motion days declared. So admission hearing or hearing matters will not be taken up. No point listing it. Matter be listed on 8th of January.
Lordship, 8 of them.
May I please, Lordship? I beg to mention listing a repetition, my lord. It was listed on last month, early in June, my lord. Thereafter, it was not listed. 24th November. For admission. Admission, my lord.
My lord, the application for withdrawal of repetition, my lord.
Tomorrow.
My lord.
Please, Lordship, I'd like to mention item number 49 of the supply list, Lordship. There's some personal difficulty on behalf of the petitioners, Lordship. Matter may be taken up next Tuesday, Lordship, or Thursday.
Part heard matter.
Lordship.
27th.
Lordship. Much of.
The request made by your Mr.
Why would we, Lordship?
Y. Borbui, appearing on behalf of Mr. Appearing for the petitioner, expressing personal difficulty of the arguing counsel, Mr. H. Gupta. Matter stands deferred to be listed on 27th of November.
Much of.
Have you informed the other side?
Lordship, I'll.
Please inform the other side.
Lordship.
Who's there? CGC is there.
Yes,
MSS Borua appears for
is state government or city.
state government. Yes.
Lordship, item number 45.
Hmm.
Can we pass over the matter for today?
Item 45. Why there are some trial court records have been called for? Item 45 on a request made on behalf of the counsel for the petitioner stands passed over for the day. Who's for the other side? Have you informed?
No, Lord.
Please go and inform first. We are not adjourning it unless you inform. Cut it off.
They don't give any.
No, first you inform the other side that you are not having the matter today.
For state, we appear.
You are appearing?
But so for state, Lordship, private respondent is also there.
All right, 45 on the request made by so-and-so stands deferred. Yes. Then pass over.
Yeah, please, Lordship. Lordship, I beg to mention for listing up of a matter, Lordship. Matter is of 2022. And it was last posted on 27/8/2025. Lordship may kindly list the matter on any date next week.
No. What is the matter about?
Matter is relating to retirement benefits, Lordship.
28th of November.
28th of life.
Yes. Why don't some of you come to the other podium? Yes.
May I please, Lordship? Lordship, I would like to pay for listing of a new matter, Lordship.
New matter.
New matter, yes.
When was it filed?
On 18th of November.
18 November.
Yes, Your Lordship.
Today is 20. So it will come on its own. Why you pressing it? When do you want it?
Lordship,
When do you want the matter to be listed?
on Monday.
On Monday, all right, Monday, subject to clearance of defects. Yes, 24th. Fill up your date in the mention memo. Do you have a mention memo?
Yes, yes, Your Lordship.
Fill it up, 24th.
Okay.
Give it to the court master.
May
Yes.
I oblige, Your Lordship?
May I pray for listing of a fresh matter for motion, Lordship, tomorrow, Lordship. Matter was filed on 15th, Lordship, of this.
All right, tomorrow.
May I please, Your Lordship? I beg to mention for listing of motion matter, my lord. Monday, my lord.
Monday, 24th.
Oblige.
Yes.
Maybe the lordship, I beg to mention for listing, my lord. Matter is 2023, my lord. So, my lord, this is a pension matter, my lord. Any date may be fixed.
1st of December. 1st December. Yes.
Okay, madam.
I'm paying for listing on,
Listing for what?
listing for
Admission.
admission.
What matter? What is the subject matter?
Termination from,
Hmm?
termination from service matter.
Termination from service.
On listed date on 26, my lordship.
Not 26th. On 3rd of December. 3rd of December.
Supplementary list for orders, item 46.
Yes.
Wait, please, Your Lordship.
Yes.
My lord, we have filed this IA, my lord. My lord, what has happened in this case, despite the 90 days period of suspension being over, there has been no review. And on the last occasion, they admitted to the fact that there has been no review. In fact, my lord, we have, what have happened now, they have started the disciplinary departmental proceedings. And my lord, in the IA, my lord, that they on the Annexure D, page 25, my lord,
Yes.
it's on 18/21 or 10 AM. And my lord, in this regard, I had proposed to hold regular hearing of the above departmental inquiry from 5/11 to 7/11, but due to official exchanges, now it has been rescheduled as per mentioned hereunder. Now, my lord, while this matter was pending, we came across a judgment of Karnataka High Court with regard to SBI. I know, my lord, there is a persuasive value in this. And my lord, maybe this is binding also on the fact that SBI being a one unit, they have applied the Ajay Chaudhary's judgment. And accordingly, these similar situated persons in Bangalore in Karnataka has been asked to reinstate in his service and to continue the regular proceeding. The judgment is at page 19, my lord. The petitioner,
Who's for the other side?
my lord, there is a standing counsel, H. Burhago, my lord. We have given him the copy also. In fact, in the last date, my lord, he has admitted to the fact that the review has not been done. My lord, in fact, it's in the order dated 6/11, page number 14. The issue involved, may I just read, man?
Yes.
I'm sorry, my lord, if I'm going.
No, read the last order.
Yes, my lord, that's 6/11, my lord. Heard SP Sharma so and so, the issue involved in this petition is non-renewing the suspension order in terms of the decision in the apex court in the case of Ajay Chaudhary versus Union of India reported in so and so. H. Burhago submitted under relevant rules of there is no provision of review as laid down the decision of the apex court. However, under Rule 68A of the State Bank of India officers, after conclusion of the inquiry, it is in the event it is found that delinquent officer has been unfairly kept in suspension, he shall be granted a full pay. It appears that no return has been filed till date on behalf of the respondent. Let the returns be filed before the next date of listing. It is needless to care, failing to file affidavit in reply, the matter should be done according with law.
my lord, this at annexure 13, annexure B, page 16. My lord, there is a review, my lord. There is a part, there is an order of review. It is at page 17, and this is the vigilance manual of the State Bank of India. 3. In order to ensure that a period of suspension is kept to the barest minimum, it has been provided that a constant review at every stage is required to be made by the competent authority. A review of the cases at quarterly intervals shall be made to put up the CGM of the circle, and a copy thereof will be forwarded.
Anyway, you have filed an IA, so we'll have to issue notice if they're not here. We'll give you a short returnable date.
My lord, till then, at least the departmental proceeding may be kept in abeyance, my lord, because it's been more than 90 days, my lord.
Let them proceed. We can set aside the proceedings if we are convinced.
Yes, my lord, but without.
Your prayer is for revoking the suspension, not the departmental proceeding.
No, my lord,
Is it under challenge now?
no, in my IA, I have prayed for keeping the operational letter in suspension, my
No,
lord,
no, why?
till the next returnable date.
Why?
Because, my lord, there has been admit
Have you have to challenge the departmental proceeding that it is illegal.
that I have challenged in my writ petition, my lord. That I have challenged.
Huh,
That I have challenged my writ petition.
you have.
Yes, my lord. That I have challenged, my lord. It's in my prayer also, my lord.
Explanation letter, reinstatement, that's all.
No, my lord,
Where have you challenged it? Page 27.
my lord, yes, my lord.
Suspension, setting aside suspension.
It should, and my lord, setting aside an explanation call letter, my lord.
Explanation is not.
Yes, but by that time, the DP had not been,
So you have to challenge it. You have to
absolutely.
challenge the DP.
At the time I filed a writ petition, the DP was not there. Yes, I absolutely
We are
understand.
not holding
Yes,
him
yeah,
responsible for.
I vote on, I
that.
vote on, I
But
vote
for
on.
us to pass an effective order, interfering or staying the department proceeding, it must be put to challenge.
My lord, as of today, this letter was only issued to us. That's why I have come for
That's
events.
right. So you are well advised to decide what to do. So far as this writ petition is concerned, essentially it is about suspension.
Yes, my lord. So, my lord, that is, otherwise, if the departmental proceedings goes on, and now the 90 days period has been over, my lord, I will be nowhere, my lord. And so that's why I'm only till the next returnable date, my lord, this may be at least kept in abeyance.
So what do you mean you'll be nowhere?
Because, my lord, if the departmental proceedings is concluded,
Huh.
my right of being reinstated as per Ajay Chaudhary and that being admitted to the fact would be flawless, my lord, because there would be.
No,
And
then,
that is
then don't press your eye.
No, I'm pressing for the IA only on this ground, my lord, that because while I may replace it again if my lord permits
If
me.
you're pressing your IA, it's a fresh IA, we'll have to issue notice.
So, my lord, then I'm pressing my writ petition. In that writ petition also I have stated this that a
Where is Mr. Buragoy? H. Buragoy. We'll call it up in a while, let him come.
Yes, my lord.
Same matter, is it?
Okay, seven.
Same, my lord.
Same matter. There are two officers,
Yes, my lord.
two officers,
Two officers. Same day, man.
two of them.
The release for admission item 1.
Yes.
Please, your lordship, some records were to be placed before this honorable court lordship as per the last order. My lord, the department is tracing the records. Some more time will be granted.
Otherwise, lordship, the matter as it stood on the last date, these are cases.
It might be fixed, lordship. They are tracing the records, lordship. That will be placed, lordship, by next week, lordship.
Sorry.
Down.
What were you saying?
I also, my lord, inquired about the records, about the original appointments. At that point of time, my lord, the difficulty is that the formal letters were not issued. Only WT messages were issued from commandant to commandant, and this pertains to 2002-3. So for us, it was not possible, but then the duty registers, etc., my lord, they would be having probably. So that can be brought into. This was required, my lord, as to, there is an admission, my lord, in their affidavit at page 111 that these people, my lord, were assigned cipher duties, my lord. So what would be their date of appointment or date of becoming Hawaldar cipher is the issue, my lord. And that is vital because dependent on that date, my lord, their ACP benefits are to be calculated. Lordship had recorded these things in the last order. We try in the first week of December, maybe.
We heard Mr. B. Pathak for the petitioner, Mr. Vaibhav Bhuiyan appearing on behalf of Mr. H. Gupta, London CDC for the respondents. As per the last order dated 3010-2025, the respondents were directed to produce the records containing the initial orders of appointment or engagement as Havildar / Cipher, CIPHER, Cipher. Stop. The learned CG council on behalf of the CGC submits that they require further 1 week's time, 1 week to trace out the records and place it before the court. Prayer made is not objected to by the council for the petitioner. List this matter again on 5th of December. Fifth.
Oh, my lord. Yes, yes. 5th.
Yes.
I was looking at a 26 calendar. 5th December
26.
26 is Saturday, man. Otherwise, I'll okay, man.
Yes.
Obliged.
Maybe.
Record হৈছে নেকি? ৰেকৰ্ডটো হেৰি আছে ৰ'বা। মানে record was malot the department sent to the malot registry high court. Today I have learned that malot that record has been sent to our office today. I will get it. Malot another date may fix for malot peruse the record.
What is your ground for challenge?
My lord, here the penalty of censure, my lord, is put to challenge. Firstly, my lord, the ground of challenge is that
You file the appeals also, dismissed.
my lord, appeal not filed, not dismissed.
Why?
Appeal, my lord, already he is retired, retired IPS officer. And my lord, since the inquiry report is challenged on the ground of perversity, my lord, that there is no evidence at all. So perhaps your lordship, in absence of the alternative remedy, also can take up. Because, my lord, the conclusion which is arrived at is based on a document, my lord, which was never part of the, my lord, charge sheet and which was not proved, my lord, during the course of the inquiry.
Where is the inquiry report?
Inquiry report, your lordship will find, it starts, my lord, from page 70, my lord, and the conclusion part, the findings, my lord, at page 79, my lord.
78 again.
There were, my lord, 3 charges. And in respect of article charge number 1 and 3, the inquiry officer, my lord, has held that it is not proved. And in respect of article, my lord, 2, if your lordship comes to page 79, article 2, the first part is not proved. The second part, my lord, the inquiry officer proceeds to hold. However, the charges of coercing ABSI Suryakant Barua of PTC Dergaon to write a false report is found to be true, as there is seen to be no valid reason for us, the witness, to resort to any falsehood as imputed by the charged officer. Under the above circumstances, the charge of misconduct on the part of the charged officer is proved. The charge was, my lord, that I had coerced this particular officer to prepare a false report. Now, that false report, my lord, is not part of the documents in the charge sheet, my lord. And this, my lord, particular document is also not proved, exhibited during the course of the inquiry. And I don't know what was the document, my lord. And the inquiry officer proceeds to hold that, my lord, this is proved, my lord. On the ground,
Just 1 minute.
my lord,
Just one. Yes. Yes, yes, carry on,
Yes.
please.
Yes, my lord my lord has seen, my lord, that the inquiry officer has come to the conclusion that the charge is proved on the ground that as there is seen to be no valid reason for the witness to resort to any falsehood. So on assumption, my lord, the inquiry officer has reached the conclusion that there was certain coercion on my part in preparation of the, my lord, report. So this is, my lord, what the inquiry officer said is proof. So your lordship will find that the particular report, which is purportedly a forged one, is not part of the documents, my lord, which is, my lord, the part of the charge sheet. If your lordship comes to, my lord, the charge memo, and precisely, my lord, to the documents on which the disciplinary, my lord, authority relies on, page 24, list of documents, my lord. These are only the documents which were furnished to me. There are 4 numbers of documents, my lord, and that particular report is not part of the list of documents. That is not furnished to me, and more particularly, on the top of it, that was never proved, my lord, during the course of the inquiry. And Rup Singh,
Which document are you referring to?
my lord, the inquiry officer proceeds to hold that a certain, my lord, report was prepared by the, my lord, delinquent on coercion by ABSI Suryakant. If your lordship again comes to page 79, I'll come to the charge. He says, the second part of Article 2, however, the charges of coercing ABSI Suryakant Barua of Dergaon to write a false report. Allegation is that I have coerced to write a false report by one Suryakant Barua. That report is totally extraneous, my lord, so far as the proceeding is concerned.
No, but that is a part of your charge.
That is part of my charge, but the document.
What is your reply to that?
Yes, my lord. My reply, if your lordship comes to written statement,
Page number?
page, my lord, 31.
You have replied at page 32.
Yes,
You deny it.
I deny it, my lord.
No.
But
It is not your case that the report is not a part of the documents furnished. I did not get to see the report. You deny it.
that is correct, my lord. What I'm on, that if the inquiry officer, my lord, is basing on a document.
Right. If it
Correct.
is to be perverse,
My lord.
they're taking materials which are not relevant, irrelevant materials to come to a conclusion. If it is irrelevant, then at the first instance, you should object that this is not there, it's not been served on me. It's not a part of the list of documents.
Yes, that objection perhaps is not in the written
It's not
statement.
there.
That
You
is correct.
You have denied. I categorically deny.
Yes.
You denied means you are aware.
No, in fact, my lord, your lordship is aware that, my lord, when a particular document is relied on, my lord, I'll come to the Supreme Court judgment. When a particular document is relied on, my lord, it has to be proved or exhibited during the course of the inquiry, so that I get a due opportunity, my lord, to defend myself in respect of that document. And I don't know what is the document they are going to place during the course of the inquiry. I may have known some documents, my lord, but it is, my lord, it is incumbent on the disciplinary authority.
The scope of judicial review is generally limited in a sense that we are not an appellate court. We are not supposed to examine each and every document, whether it is there, not there, how it is placed, not placed.
Correct.
You are raising the plea of perversity.
Right.
So for perversity, you must say that these are the documents given to me, these are examined, and this is the conclusion which has no relevance to the process of inquiry conducted. Here, it appears that the charge itself was that you had prepared through somebody a false report. You reply that you deny it.
Right.
It is not your case that this document was never supplied to me, therefore I did not know what it was there.
Yes, correct.
This is something which you are taking up for the first time, perhaps.
Correct, my lord. What I'm trying to say, my lord, the inquiry authority, my lord, might not have, my lord, supplied me the document. Now, My lord, I have said that I have not coerced. That is, I was not instrumental in preparation of such, my lord, report. Now, what, my lord,
Is it-
would be the report?
Is it,
What?
is it beyond reasonable doubt? The standard of proof, is it beyond reasonable doubt?
No, my lord, what I'm trying to say, my lord, I may not be able to put across the point. What I'm trying to say, that I don't know during the inquiry, what will be the report. I may be talking of some report and the disciplinary authority might have, my lord, based on, rely on some other document, my lord.
You see, the whole purpose of inquiry is to get to the root of the allegations.
Yes.
So there must be some effort from the part of the delinquent to say that these allegations are not met because of no evidence or irrelevant documents or non-furnishing of documents.
My lord, even then also, my lord, in terms of the, my lord, rules holding the field, Central Discipline Appeals was 1969.
This is
My lord,
central.
Yes,
This is central.
Central, my lord. He's an IPS officer. Now the rule says that you should supply the documents
No,
on
this
which
this was at a time when he was an APS officer.
IPS officer.
Hmm?
IPS officer.
Where is the show cause?
Show cause page 21, my lord. Para 2, it says, my lord, the IPS officer. And they have also relied on the central rule, 1969. Now, rule is very specific that when you rely on a charge in respect of a particular charge and rely on a document, you have to furnish that document, my lord. Rule is very specific, my lord. Now, their entire, my lord, case is in respect of that forged document or that particular document, which is allegedly, my lord.
So the records will be necessary. Have
Oh,
you got
yes.
the records?
I have got it, my lord.
You go through it and tell
Yes,
us
yes, I have got to go to. So under that maybe please. my
what
lord.
records, what report was relied on? Was it furnished to him?
Yes,
Was he in the know of the report? The depositions must be there in the record.
Definitely, my lord.
When can we have it?
November. 20.
4th December?
Yes, 4 December.
4th December, Mr.
Mal.
Talukdar?
Mal.
Third counsel for parties, Mr. T.C. Sutia, Leonard. Government advocate submits that he has received the departmental proceeding records in court today. He prays for a short accommodation to apprise himself with the contents of the records, official records. Accordingly, as agreed to by the parties, let the matter agreed to by the council for the parties list on 4th of December. Published. The records received be retained by the government officer, by the government council.
Agree.
SBI কিবা আহা কথা আছিল যে। Yes.
The matter may be went after the Supreme Court.
What is that? What is the matter about?
Lordship, I had challenged the rule of the NRL, Lordship. And that was, the same thing was taken up before the division bench here. It went in my favor.
Then it
They
went in appeal.
They went
Order
in
appeal.
appeal, Lordship. And that is pending there, Lordship.
So therefore, it has to be after.
Lordship, after some time, Lordship.
The issue raised in this matter is presently pending before the apex court in SLP number 309040 of 2025. By order dated 3/11/25, notice in the matter has been issued, making it returnable after 6 weeks. Considering the fact that considering the submission of the counsel for the parties that the issue in the present writ petition is presently in session the apex court, matter be called up after 8 weeks.
After vacation, man.
After 8 weeks.
Time being, I think 46 and 47.
May I please your lordship? The youngest counsel of this case is out of station due to his father's treatment. So kindly fix the matter on 26 as the main WPC was fixed on 26.
There is an IA praying for a stay. There is an IA praying for a stay. Heard Mr. S.P. Sharma, learned counsel for the petitioner. MS
As Paul, appearing on behalf of
appearing on behalf of Mr. H. Puragonin, standing counsel SBI. So this IA has been filed, praying for stay of the further proceedings of the departmental inquiry initiated against the writ petitioner by notice dated 3/11/2025. Stop. The connecting writ petition being WPC number so and so was directed to be listed on 26/11. Accordingly, let this IA also be listed on 26/11/2025. We can only say that department, if they proceed, shall not pass final orders.
No coursive action also do till the next sitting.
No coercive action is very vague. We can't stay it because it is not under challenge. We can say that don't pass final orders.
My lord.
In the event, the department proceeds with a departmental inquiry as per communication dated 3/11/2025 against the writ petition. No final orders. In the event the proceeding concludes, then no final orders be passed in the same matter till the next date fixed. This 26/12.
My lord.
List accordingly. 26/11. And the counsel for petitioner will serve extra copies of the IA on the counsel appearing for the respondent.
47.
much obliged.
Same.
Same matter, same issue. Same order.
I think 4 to 40.
My lord, in the item number, my lord, 5, 6, 7, 8, 9, and 18. And then we have been permitted to verify the record, my lord. But unfortunately, my lord, friend, my lord, he left the record at home, my lord. So my matter, my lord, worship give us,
Who is your learned friend?
D. Gogoi, my lord.
Where is
Mr.
he?
Gogoi.
Where is Mr. Gogoi?
Gogoi is Kumano. This Upamanyu will appear.
Lordship, matter may kindly be taken up on Tuesday or after some time, Lordship.
Why?
Upamanyu is on Lex in a hearing, Lordship. Dear.
But these are fixed.
That's it. For the time being, otherwise, Lordship.
Record, my lord, he left at home, my lord. By mistakenly, he powered this one.
Then, Lordship, may I say, Lordship, on Tuesday, Lordship.
No, let him come, let him come. We are keeping it aside for the time being, let him come. Let him come and address the court.
Lordship.
My lord. In item, my lord,
These are all connected matters.
connected,
Why
but
are you segregating it?
not segregating.
Ah,
It's not.
what? Very good order. Ah, very good. Ah. Notice it was a good.
I think 48.
Made please, your lordship. In this case, your lordship, I am challenging the order by which I was terminated from service. Your lordship may kindly peruse the order at page 31. Before I submit, Your Lordship, in this case, no charge sheet was submitted to me and no inquiry report was ever provided to me. No charge sheet was submitted, no charge sheet was given to me and no inquiry report was provided to me, Your Lordship.
This
The
for
order,
the ASIDC? Yes.
I got the records. The order, Your
No
Lordship.
charge sheet.
No charge sheet, Your Lordship, may kindly peruse page 28 for a moment. 28. Page 28. There is the SOCOS notice and suspension order, Your Lordship. May I read, Your Lordship? It has been reported to the undersigned by Sri Priyo Kumar Sinha, Junior Assistant cum Computer Operator, PA to MD, who has been allotted the duties of keeping attendance of the employees of ASIDC and AAP through biometric attendance machine, that on 2nd November 2022 at around 5 p.m. you were found in drunken state and had fiddled with the biometric attendance machine when the employees came to put their attendance. It is also alleged that you had delivered a few blows on the machine in spite of requesting by Sri Singh. Also, you have shown abusive language to him. It is gross violation of office discipline, decorum, and misconduct. In view of the gravity of the alleged misconduct, you are hereby placed under suspension with immediate effect. Your reply should reach to the undersigned within 5th November 2022 as to why disciplinary action should not be taken again. So this was the SOCOS notice, Your Lordship. Therefore, no charge sheet was filed. Then, Your Lordship, may kindly peruse page 32. Page 32, Your Lordship. Now, may I read, Your Lordship? That is the order. It starts from page 31. Relevant portions, page 32. Now, therefore, Your Lordship, may I read? Now, therefore, Your Lordship got it.
Yes.
Now, therefore, having regard to the finding of the inquiry officer and taking into account the inquiry report, relevant documents and facts and circumstances of the case, even after his act of furious behavior with office duty Sokidar on 31st December 2022 night as reported by the victim, the undersigned in terms of Rule 7 of the Assam Service Discipline and Appeal Rules 1964 is of the view, considering the gravity of the misconduct, ends of justice would be met if the penalty of removal from the service, which shall not be disqualification for future employment prescribed under Rule 7(6) of the Assam Discipline and Appeal Rules 1964 is imposed upon him. Now, the initial SOCOS notice, Your Lordship, may kindly peruse. It was with respect to the fiddling of the biometric machine. This was considered in, but Your Lordship, this with respect to this part, that he has he has behaved furiously with the duty of his Sokidar was never a part of
This is what? This is the inquiry report.
This is the
This
order.
is the
Your
order.
Lordship. This is the termination order. Order has been discussed, Your Lordship.
But no charge sheet, no reply.
No
Inquiry.
No
Inquiry
inquiry
was
was conducted, but with respect to this particular aspect, no inquiry was conducted, Your Lordship. Neither any charge was framed against me in this regard, Your Lordship. Now, Your Lordship, may kindly peruse their affidavit. The affidavit filed by the respondents, Your Lordship. At page 46, running page 46, Your Lordship. This was the original complaint. May I read, Your Lordship? With reference to the subject cited above, may I inform you that I have been given the duty of looking after the attendance of the employees of ASIDC Limited, including up with the help of the biometric attendance machine that has been installed in the head office. I have been keeping records of the attendance registers of attendance obtained from the biometric attendance machine in my office computer on a regular basis. But on 2nd November 2022, when I had extracted the attendance from the biometric attendance machine into my computer, I find the attendance of all the employees have been marked as absent for the 2nd of November 2022, although the employees had attended office. In this regard, may I further inform you that Sri Devojit Soikia, Sub-Engineer Construction and TS Division, in a drunken state had fiddled with the biometric attendance machine on the evening around 5 p.m. on 2nd November 2022 when the employees had come give their attendance. He had delivered a few blows on the machine and in spite of my request, him to remove or to move aside so that the other employees could give their attendance with the stipulated time. He was quite rude and abusive in his manner and language. A video of the screen capture with my mobile phone is present as evidence on the screen that Sri Devajit Soike had created. Now, thereafter, the inquiry report, Your Lordship, may kindly peruse the inquiry report. The charges, Your Lordship, page 48. Only the second part, Your Lordship, the second paragraph, not the first paragraph, with the heading charge of allegation against the DO. The allegation against the page 48 of the same affidavit, Your Lordship.
48.
48. That's the inquiry report, Your Lordship.
Forty-eight is the inquiry report.
Inquiry report, Your Lordship. The second part, Your Lordship. I'm relying on that the charge, under the heading charge of allegation against the DO. The second paragraph, Your Lordship, the allegation against the delinquent official are dated on 2nd November 2022 at around 5 p.m. He was found in drunken state and fiddled with the biometric attendance machine when the employees came to put their attendance. It is also alleged that he had delivered a few blows on the machine in spite of requesting by Sri Priya Kumar Sinha. He had also shown that abusive language to him, which amounts to gross violation of the office discipline and decorum and misconduct. And then Your Lordship may kindly peruse page 49. Page 49, inspection and confirmation of documents, Your Lordship. I'm reading from the second paragraph. The prosecution witness, Sri Priya Kumar Sinha, alleged that the DO mishandled the biometric attendance machine in spite of requesting. The DO has shown abusive language to him. Sri Priya Sinha showed the incident in the videography. All other prosecution witnesses supported the version in favor of Sri Priya Sinha. Moreover, Sri Ratul Kumar Mohanto and Sri Bipul Borduri, both are adjacent neighbor of staff quarter of the DO, alleged that sometimes they felt disturbed of the abusive language and loud voice of the DO that polluted the environment. Further, Sri Hiren Bora and Sri Narayan Sharma Gate Chokidar alleged that sometimes they faced thunder, threatening and abuse language of DO at night duty during their duty. In response to the charges established against him, the DO admitted that he had made mistake and requested the authority to relieve him of the mistake done and applied for such mistake. He also assured that he will not do such activities in near future. So there was the finding, Your Lordship. On analysis of records of the DO and documents along with available during the course of inquiry, it is found that the allegation brought against him, the DO, are true and based on facts and documents. Now, my respectful submission, Your Lordship, in this case, I'm relying on the Assam Service Discipline and Appeal Rules, 1964. Lordship may kindly peruse Rule 10.
Yes.
So it is under major penalties. And then Your Lordship may kindly peruse Manual of Departmental Proceeding 3.13.3. May I read, Your Lordship?
Yes.
30, various stages of departmental proceeding and time limits for the stages. The disciplinary authority should invariably obtain all relevant papers and documents on which it intends to base the charges and statement of allegations without delay and keep them ready so that access thereto may be given readily whenever such request is made by the delinquent official. Charges and statement of allegations should be framed as soon as possible. When the officer proceeded against is placed under suspension, it should be in no case take more than 15 days from the date of placing the officer under suspension. The charge sheet should be specifically contain the designation of the inquiring authority appointed for the purpose. Now, in this case, Your Lordship, neither the charge sheet was framed nor it was provided to me, Your Lordship. And their affidavit that they have filed, Your Lordship, also doesn't state that they have filed a charge sheet or they have given a copy. I'm relying on a judgment of the Honorable Supreme Court, Your Lordship. Before I proceed any further, Your Lordship, I have to admit one thing, Your Lordship. On that day, on a pointed query by this Honorable Court, that whether an appeal has been filed, Your Lordship, whether an appeal has been filed by this petitioner, Your Lordship, I was instructed that he had filed an appeal, Your Lordship. However, later on when I inquired with him, he has told that he had no idea, Your Lordship. He cannot specify as to
No,
whether
because
he
you are
forgot.
not served with the inquiry report.
No, Your Lordship.
There was no question of appeal.
Yes, Your Lordship.
How can you file an appeal?
And then, Your Lordship, I'm relying on a judgment of the Honorable Supreme Court. Yeah, 1971, Supreme Court 752.
Who's the party name?
Your Lordship, Surat Chakraborty versus West Bengal.
All right, you give your citation, the AIR.
Yeah, 1971, Supreme Court 752, Your Lordship, paragraph 4.
752.
752, Your Lordship, paragraph 4.
You listen to this? Huh? Inside this input. Huh? Yes.
I'm sorry, Your Lordship, by 71. Okay, okay. Paragraph, Your Lordship says 71 citation is not finding, and then AR 2012 Supreme Court 181.
Surat Chandra Chakraborty.
Yes, Your Lordship, paragraph 4. Your Lordship, the citation is,
Not here.
it's not in my file, Your Lordship, but I'm relying. Sorry, Your Lordship, it's there in here. I'm sorry, Your Lordship. Para 4, Your Lordship.
Oh, yeah. Yes, tell us.
Your Lordship, at page 756, internal page.
Para 4.
Para 4, Your Lordship.
Yes.
Para 4, I'm not reading the entire paragraph, Your Lordship. I'm reading from page 756, internal page, Your Lordship. I'm reading from the second line. We are unable to agree. May I read it?
You get a very good. No, that about 11:30. 11:40 go. Automatic and election by go there. Only gonna have make it. Yes.
Your Lordship, 756. We are unable to agree that the details without which, may I read? We are unable to agree that the details without which a delinquent survey cannot properly be defend himself from.
Yes, 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 yes.
We are unable to agree that the details without which the delinquent servant cannot properly defend himself are matter of evidence. In this connection, reference may be made to Fundamental Rule 55, which provides interrelated without prejudice to the provisions of Public Servants Inquiry Act 1850, no order of dismissal, removal, or reduction shall be passed on a member of service unless he is informed in writing of the grounds on which it is proposed to take action and has been afforded an adequate opportunity of defending himself. The grounds on which it is proposed to take action have to be reduced to the form of definite charge or charges which have to be communicated to the person charged, together with the statement of allegation on which each charge is based, and any other circumstances which is proposed to be taken into consideration in passing orders has also to be stated. This rule embodies a principle which is one of the basic contents of a reasonable or adequate opportunity for defending oneself.
If the person is not told clearly and definitely what the allegations are on which the charges preferred against him are founded, he cannot possibly, by projecting his own imagination, discover all the facts and circumstances that may be in the contemplation of the authorities to be established against him. This is what I'm relying on, Your Lordship. Then, Your Lordship, the another case I'm relying on is Air 2012 Supreme Court Supplementary one.
So for what is the proposition that you are relying on this?
Your Lordship, in this case, the charges were not from another charges. The charge sheet was given to me. Here in this case, Your Lordship, it's very clear that it has to be given. Definite charge has to be formed. No charge was framed against me, Your Lordship. This is very clear, Your Lordship. The grounds on which it is proposed to take action have to be reduced to the form of definite charge or charges which have to be communicated to the person charged together with a statement of allegations. So no statement of allegation, no charge has been framed against me, Your Lordship. Neither it was communicated to me.
Yes. Next.
Your Lordship, another judgment I'm relying on Air 2012. See, Supply 181. Air 2012 Supreme Court Supplementary 181, Your Lordship. Paragraph 8 and 10. 8, 9 and 10, Your Lordship. 9. May I read, Your Lordship?
Yes.
We also find that along with the charge sheet dated 31/1/1989, no statement of imputations giving the particulars of the loan accounts of the names of the borrowers, the amounts of loan sanctioned, disbursed, and misappropriated furnished to the appellant, and yet the disciplinary authority has called upon the applicant to submit his written defense statement in reply to the charges. We fail to appreciate how the appellant could have submitted his written statement in defense in respect of the charges, and how a fair inquiry could be held unless he was furnished with the particulars of the loan accounts or the names of the borrowers. The amounts of loan sanctioned, the amounts actually disbursed, and the amounts misappropriated were also furnished in the charge sheet. As is held by this court in Sundar Chakraborty versus State of West Bengal, the grounds on which it is proposed to take action have to be reduced to the form of a definite charge or charges, which have to be communicated to the person charged together with a statement of allegation on which each charge is based, and any other circumstances which is proposed to be taken into consideration in passing orders has also to be stated. This rule embodies a principle which is one of the basic contents of a reasonable or adequate opportunity for defending oneself. If a person is not told clearly and definitely what the allegations are on which the charges preferred against him are founded, he cannot possibly, by projecting his own imagination, discover all the facts and circumstances that may be in the contemplation of the authorities to be established against him. This position of law has been reiterated in the recent case of Union of India versus Gyanchand Chattar, and in paragraph 35 of the judgment as reported in the SCC, this court has observed that the law can be summarized that an inquiry is to be conducted against any person giving strict adherence to the statutory provisions and principles of natural justice, and the charges should be specific, definite, and give details of the incident which form the basis of charges, and no inquiry could be sustained on vague charges. So my respectful submission, Your Lordship, considering the inquiry was not conducted in a proper manner, and that the termination order may be set aside, Your Lordship. But the termination order may be set aside, Your Lordship.
Yes.
I have gone through the records, but charges were definitely not framed. They were not framed also, and the first notice also do not reveal regarding any framing of charge. And with regard to my communication of the inquiry report, but it can be so that if
Charges are not framed,
Yes.
they are not definite charges, then how will he,
my lord,
how will he reply to that?
there is nothing done.
He's terminated.
Yes,
Yes.
What is your age now?
I'm 60, about to reach 60 years old. Exact. I'll be.
What is the superannuation age?
60.
60 years.
Yeah. Are you entitled to any pensionary benefits?
Yes, Your Lordship.
Hmm?
Yes, your lordship. I
No,
will
no,
do-
from the organization, do you give pensionary benefits?
My lord, pension perhaps is not there, my lord, that.
Which one, Arsenal? I give the pension. Would you look at pension?
I'll take the instruction, my lord.
The instructions is okay, but
Such a, pension benefit for pension is in India. Pension is in India, no? Pension Pamuli goes one day.
what do you have to say regarding the judgments? Referred.
Yes, it is, my lord, on record, my lord, that charges were not framed, my lord. So
No, no, yeah, don't do this.
It heard Mr. T. Deori, does it counsel with the petitioner? Mr. A. Das, does it counsel representative? The ASIDC? What is it?
Assam Small Industries Development
Assam
Corporation.
Small Industries Development Corporation Limited and its officers, namely responsible smoothly and board. MS, who's appearing for industry department? MSS Borua appears for respondent number 1. The petitioner before this court was employed as a junior engineer under the respondent number 2. He was appointed as a draftsman within bracket sub-engineer civil -1 in the Assam Small Industries Development Corporation. And he continued in the same post, in the same position till he was terminated from service. So, petitioner was regularized in his services with effect from 10/9/1996 and has been drawing a regular scale of pay since then. Petitioner was overlooked for promotion and his juniors were promoted, leading to a lot of heartburning of the red petitioner. So, because of the stagnation that we have suffered, as also the ailing, as also the ailment suffered by his wife. He was mentally not in the sound frame of mind. So, being thus situated on 3/11/2022, the petitioner was served with a show cause notice and suspension order issued by the respondent number 3, ID notice number so and so dated 3/11/2022, thereby placing the petitioner under suspension with immediate effect. So, it is the case of the petitioner before this court that petitioner was not given any copy of any written complaint lodged by any person regarding any conduct, misconduct / offense allegedly committed by the petitioner. So the allegation against the writ petitioner is that on 2/11/2022 at 5 p.m., petitioner in an inebriated state had fiddled with the biometric attendance of machine by striking a few blows on the machine and used abusive language against one Sri Priyo Kumar Sinha, junior assistant cum computer operator, and in gross violation of the office discipline, decorum and conduct. Under such circumstances, the petitioner, the respondent number 3, had placed the petitioner under suspension with immediate effect on 3/11/2022 and called for explanation / reply within 2 days from the petitioner as to why disciplinary action as contemplated cannot be taken against the petitioner. So, the petitioner submitted his reply expressing regret for what had happened and also tendering apology to Mr. Sinha, who called for any hurt posed to him. In his explanation, petitioner submitted that he had actually slipped and fell down and in that process he had in that process the biometric machine was struck while the petitioner was on his way to record attendance. Stop. Since Mr. Sinha had asked him to vacate his profession, there was some exchange of words for which the petitioner tendered his apology. So. Pursuant to the receipt of the reply filed by the petitioner, the respondent number 3 appointed the respondent number 4, general manager, as the inquiry officer to submit an inquiry report in the departmental proceedings drawn up against the petitioner, and 1 MB Abdul Hamid, assistant manager construction, TS division. Stop. Presenting officer was also appointed. So who is Abdul Hamid?
The presenting officer.
Oh, sorry. The disciplinary proceeding was drawn up, and one Sri Abdul Hamid was appointed as the presenting officer. The proceedings were initiated under the provisions of the Assam Service Discipline and Appeal Rules, 1964. Stop. The inquiry was conducted. The petitioner participated in the inquiry. However, no statement of allegation or notice was served on the petitioner. And subsequently, the inquiry report was submitted, and the impugned order where is the impugned order?
Page 31, Your Lordship.
The impugned order dated 30/01/2023 was issued by the respondent number 3, whereby the penalty under Rule 7 within bracket Roman 6 of the Discipline and Appeal Rules 1964 was imposed, and the petitioner was terminated from the services of the corporation with immediate effect. Yeah, it is the submission to the council for the petitioner that as per the rules of 1964, read with the manual of departmental proceeding, as also the law laid down consistently, law laid down by the apex court. Petitioner is entitled to be served with a copy of the charges frame, the statement of allegations, and the list of documents and witnesses to be relied upon by the department. Stop. That apart, the petitioner is required to be permitted to respond to the charges framed by filing his written statements. Did you file any written statement? Did you file any written statement?
No, Your Lordship.
However, he was not.
I filed a reply, Your Lordship.
You filed a reply to?
Reply to the so-called notices, but no written statement.
Although he filed a reply, but no written statement in respect of the charges level could have been filed by the petitioner as no specific charges were framed against the writ petition. Stop. Although the petitioner was permitted to participate in the inquiry proceedings, the inquiry report was never served on the writ petitioner, and as a consequence thereof, he could not prefer any appeal before any departmental authority. Stop. Under such circumstances, it is submitted that the manner and the procedure adopted by the respondent department for initiating and conducting the inquiry report is, besides being contrary to the rules of 1964, is opposed to the basic rules of natural justice and the law laid down by the apex court in this context. So, in support of his contentions, the learned counsel has placed reliance on the judgments of the apex court rendered in Surat Chandra Chakravarti, reported in AIL SC 752, and Anil Gilurkar is reported in AIL 2012 SC within bracket supply SUPP bracket 181. So, pressing this judgment into service, the learned counsel for the petitioner submits that the inquiry conducted against the petitioner is no inquiry in the eye of law, as the procedure prescribed under the rules of 1964 were not followed by the respondent authority, and no opportunity of effective hearing was granted to the writ petition. So, Mr. S. Das, studying counsel for the department, on the other end submits that you have the records.
Yes, ma'am.
Records that the petitioner had replied to the show cause session, and he was also permitted to participate in the proceedings. Therefore, it cannot be said that the petitioner that the inquiry was conducted in violation of the rules of natural justice. So, referring to the reply submitted, where is your reply?
Page 28. Your Lordship.
29.
Of my petition, page 29, Your Lordship.
Submitting was reply to the petitioner. Referring to the reply to the petitioner, he submits that the allegation made against the petitioner have been admitted by the petitioner in his reply. Stop. He had admitted that he did not deny that the incident never took place. However, and after tendered apology for condoning his act, condoning his action in respect of the same inquiry, in respect of the same incident, stop. Therefore, there is no prejudice caused to the writ petitioner in the as the petitioner has already submitted his reply. Stop. He, however, fairly submits that the records do not reflect whether the inquiry report had been furnished to the writ petition. Learned counsel for the parties have been heard, meetings available on record have been carefully published. At the outset, it is necessary to refer to the 1964 rules. So, Rule 9 lays down the procedure for imposition of penalties. Sorry, Rule 7, all the said rules lays down the procedure, lays down the punishments prescribed. the punishment imposed on the writ petitioner is under Rule 7 within bracket Roman 6, which is removal from service, which shall not be a disqualification for further employment within courts. Stop. Under Rule 9, the procedure for imposition of the penalties under Rule 7 have been laid down in detail. Stop. Rule 9(2) specifically provides that the disciplinary authority shall frame definite charges on the basis of allegations on which the inquiry is proposed to be held. Stop. Such charges, together with the statement of allegations on which they are based, shall be communicated in writing to the government server, and he shall be required to submit within such time as may be specified by the disciplinary authority a written statement of defense, and also to state whether he desires to be heard in person. Rule 9(3) prescribes that the government servant shall, for the purpose of preparing his defense, be permitted to inspect and take extracts from such official records as he may specify, provided such permission may be refused if, for reasons to be recorded in writing, in the opinion of the disciplinary authority, such records are not relevant for the purpose or is against the public interest to allow him access thereto. Under Rule 9(4), it is provided that upon receipt of the statement of defense, written statement of defense, or if no such statement is received within the specific time, the disciplinary authority may inquire into such charges as are not admitted, or if it considers it necessary so to do, appoint for the purpose a board of inquiry or an inquiry officer. Stop. Under Rule 9(5), the presenting officer on behalf of the disciplinary authority may be appointed. Stop. Rule 9(6) prescribes that the government servant shall be entitled to cross-examine witnesses examined in support of the charges and to give evidence in person and to deduce documentary and oral evidence in his defense. Person presenting the case in support of the charges also shall be entitled to cross-examine the government servant and the witnesses examined in his defense. And finally, under Rule 9(7), the report at the conclusion of the inquiry should be prepared by the inquiring authority on the basis and record its findings on each of the charges together with the reasons therefore. So, under Rule 9(8), the record of inquiry is to include the following extract corridor. Rule 8, Roman 1 to 3, 1 to 6. So, having noticed the the requirement in the rules of 1964, you can see that the rules of 1964 are ordinarily required to be applied in cases of government servants. Stop. Although the writ petitioner in the present proceeding is not a government servant, but an employee of an instrumentality of the state, the fact remains that the department has proceeded to conduct the inquiry under the provisions of the 1964 rules or rules of 1964. Stop. This presupposes that the respondent department has adopted the rules for the purposes of conducting an inquiry. Stop. The impugned order of punishment as imposed on the writ petitioner within bracket annexure so and so also reflects that punishment under Rule 7 Roman 6 has been imposed. Stop. Therefore, the department has consciously adopted the rules of 1964 while conducting the departmental proceedings. Stop. If the department has adopted such rules, then unless there is any specific order passed by the concerned department exempting application of some portions of the rule, the rule, the rigors of the rule is expected to be followed by the department. Stop. From the pleadings, it is seen that although a notice was issued making allegations against the writ petitioner, notice dated 3/11/2022, terming TERMING, terming it to be within quotes show cause notice and suspension letter. The same was not followed up by issuance of a charge memo, as is mandatorily required to be prescribed under these rules. Stop. As a consequence thereof, although the petitioner submitted his reply pursuant to the show cause, the petitioner was not confronted with specific and definite charges drawn up against the petitioner, in which the department had proposed to conduct an inquiry under the provisions of the 1964 rules. Stop. In the absence of such definite and specific charges being framed against the petitioner, no specific reply would have been filed by the petitioner. Stop. The show cause notice and the suspension letter also does not specifically mention any definite charges. Stop. The documents to be relied upon and the documents and witnesses to be relied upon by the department during the process of inquiry has also not been forwarded to the petitioner, as is required to be done under the provisions of so and so rules of the rules of 1964. Stop. The further distressing conduct of the respondents that is noticed is that upon conclusion of the inquiry and prior to furnishing of the impugn termination letter, dated 3001/2023. The inquiry report as mandated under section 9 capital A has not been furnished on the writ petitioner. So no prior notice as required under section 9 capital A of the rules of 1964 requiring the department to call upon the petitioner as to why punishment as proposed in terms of the show cause notice issued should not be imposed in view of the inquiry report, in view of the conclusion of the inquiry officer. No. These procedures which are prescribed have not been followed and no explanation has been furnished by the respondents as to why these proceedings, a procedure prescribed by law, has been given a go by. In Prudak Chandra Chakraborty reported in Supra, PFX court. It held that the grounds on which the action is proposed to be taken by the department are required to be specifically informed to the delinquent officer. And he has to be afforded an adequate opportunity of defending himself. Stop. The grounds on which the proposed action is contemplated will have to be reduced to definite charge or charges which are to be communicated to the person charged. Unless such a person is informed in definite terms the charges framed and on which the department proposes to proceed for inquiry, the delinquent officer will not be able to come up with effective defense in support of his case. So the charges must be accompanied by these definite charges which are to be served on the writ petitioner or on the delinquent officer must be supported by statement of allegations as well as a list of witnesses and documents. So there are again subsequently, the judgment was again referred to in Anil Gilurkar Supra, whereby in connection with the proceeding initiated against an employee of the bank, the FX court reiterated the position laid down by the apex court in Surat Chakraborty, as also in Gyan Chand Chattar reported in so and so. The apex court held that an inquiry has to be conducted against any person giving strict adherence to the statutory provisions and the principles of natural justice, and therefore definite and giving details of charges, which forms the basis of charges. Stop. No inquiry can be conducted on the basis of vague charges. Parent. Upon considering the material before the court as also position of law as described, as exfoliated here and above, the court is of the view that the manner in which the respondent has proceeded to terminate the petitioner reflects the high-handedness which the authority proceeded without adhering to the procedures prescribed and also the basic rules of natural justice. So, while the department has relied upon the procedure prescribed under the department and under the rules of 1964 for conducting the inquiry, however, the specific provisions prescribed have not been followed, and no explanation thereto has been furnished by the respondent authority. So, the further action of the respondents in not framing any definite charges and for not furnishing the inquiry report on the petitioner after conclusion of the inquiry prior to imposition of the impugned order of termination also is contrary to the provisions of law. So, the actions of the respondents therefore needs to be interfered with as being contrary to law. So, the impugned order of termination therefore is set aside. The petitioner will be reinstated in service if he has not already crossed his age of superannuation. In the event the petitioner has crossed his age of superannuation, then all service and financial benefits that the petitioner is entitled to shall be granted to the petitioner without any further delay. Considering the fact that from a perusal of the materials before the court, it is apparent that the department has arbitrarily proceeded to terminate the petitioner without adhering to the prescribed norms, as also a procedure adopted which is opposed to the rules of natural justice. Petitioner's period under suspension shall be treated as period in service, and all service and financial benefits entitled to the petitioner shall be released. The petition regarding stands allowed to dispose of.
I'm very grateful. Highly
In order, they get influential is satisfied. To our feelings. Yes.
Very good. Highly grateful.
May I plead the lordship?
Records return. আপনি theory query. Yes.
My lord, item number 45, my lord, someone has mentioned it to be the petitioner, misrepresenting herself to be the petitioner. I am for the petitioner, my lord, actually. And
This is.
anyway, if
We'll
it has,
take it up.
but if it has been adjourned, my lord, I pray for a fixed date, my lord, because my lord, the private respondent, he is being paid by the petitioner organization.
No. Who has mentioned? We have recorded somebody's name.
Yes, my lord.
Item 45.
Actually,
Huh?
actually, they are representing respondent number 4, my lord.
Okay.
And I am for the petition. Yes, she is there, my lord. Probably it is her misconception.
You are mentioning for whom?
Respondent, my lord.
Then you mentioned petitioner.
Yes, my lord, that's right. So anyways, my lord, I pray for a fixed date because, my lord, the respondent number 4 is being paid his monthly salary without being
When do you want it?
on 4th of December, my lord.
4th December.
Yes, my lord.
4th December.
Obliged, my lord.
One query.
Lordship, may kindly take up the matter on Tuesday or Thursday. My lord, I'm not feeling well actually. You know, correct.
That is for the petitioner subjects that he is indisposed. He suddenly felt indisposed. Therefore, seeks an accommodation. This taken. Let it be in January?
My lord, next Thursday, if possible, Lordship. Some urgent.
4th of December.
4th of December.
Mr. T.C. Suthia, Lana Singh and Solution of Singh appears for the state. Yes. What is it?
Time being items 4 to 40.
Lordship, the council is still on legs.
But my lord, my dear lordship, order dated 27/3/2025, my lord.
আমার তো মানছেন কি?
27?
27/3/2025. In item, my lord, 20, my lord,
Item number?
20.
22.
Lordship was pleased to direct the source of power to issue the input notification. They have filed the affidavit, my lord. I have also filed the reply, my lord. I am ready to argue. my lord.
He has medical reports.
No, my lord, 27/3/2025, my lord.
That's
Order-
what we are looking at.
Yes, my lord. The source of power of government to issue input notification for reassessment, re-evaluation of such certificate. 27/3/2025.
Item number 20.
20, my lord. Sanjay Chauhan.
Sanjay Chauhan.
Yes, my lord. Petitioner name, my lord.
We have the order 27/3/25.
Yes, my lord. My lord, your lordship was pleased to direct, my lord.
First, we wanted the medical records.
And my lord, also my lord, medical sir, and also my lord. Furthermore, the respondent will address the petitioner condition which calls for certifying authority notify the appropriate government to issue the disability certificate confirming that the individual is a person with benign disability The respondent also clarify the source of power for the
But there is
government.
a coordinate bench who has dismissed your petition.
No, my lord, that is the OM, my lord. Here is the notification, my lord.
Huh?
That is the OM, my lord. Here is the, I am challenging the notification. Notification dated, my lord, 13/9/2023.
Page number?
Page number 58, my lord.
58.
Yes. By this notification, my lord, they have issued the reassessment process.
And what was decided in the coordinate bench, by the coordinate
Like,
bench?
that is the OM, my lord.
What
Only
OM?
one.
What
OM dated 22,
Stating what?
stating that OM is to be valid because the petitioner was not able to this,
What
challenge
was
the.
there in the OM?
My lord,
What was there in the OM?
OM. OM, my lord, the verification, re-verification. And the verification, re-verification, my lord, the OM, my lord, verification is the interpretation has been given that they can verify, re-verify. But the reassessment, that aspect was not touched in that order, my lord. Reassessment is done by
Who
the,
was that OM?
my lord. OM is at page, my lord, 53. They have said that clause 5.
Yeah, so clause 5, that is, the same thing is held. Will be subject to such verification, re-verification.
Yes, but the reassessment process under the act, my lord, there is no reassessment process.
Whatever it may be, but the coordinate bench has upheld this re-verification process. Why should we go into the hearing again?
But my
Go
lord,
and file an appeal.
yes, I have filed, my lord.
Ah.
I have already filed, but with limitation, my lord, delay condition. But my respondent has took time, my lord. But
When the matter is before the appellate court, then we'll close it by relying on the judgment of the coordinate bench.
for my lord, time may be granted. Matter may be listed after, my lord.
No, what after? Why should it be kept pending? Yes, Mr. Baruya?
My lord, on the last occasion, your lordship was pleased
No,
to
no, are
ask.
you aware of a judgment of the coordinate bench?
My lord, my case is totally different from them.
Why?
My case is, my lord, lordship kindly have a look, my lord, item number 5, my lord. Yes. My case is totally different from them, my lord. As because university got selected us, we have gone for re-verification. Then, my lord, our case was not considered. What happened in the medical board, my lord, that is totally silent. They have not filed yet any affidavit. And my prayer is only, my lord, operative part of prayer portion, lordship will see page 26.
Yes.
That they projected, my lord, we have not been access to that matter. That's why your lordship last occasion asked the education,
That's the only thing, re-verification.
re-verification.
So that has been upheld by the coordinate bench.
My lord, that is true, my lord. The as to why the appointment to the petitioner, then lordship, mandamus and shall not be issued, directing the respondent to appoint the C, my lord, mandation appropriate order direction, directing the respondent of 4th to cause medical re-verification.
That's right, re-verification has to be medical re-verification.
No, again, my lord, because,
That is what we are trying to point out in the.
yes, my
OM.
lord.
In the
Because,
OM.
my lord, during pendency of the case, my lord, they have again, my lord, re-examined me and found, my lord, I am disabled person. That's, I have given an original copy is with me, though I have filed, my lord.
Who has examined you?
Medical college, my lord. Guwahati Medical. Lordship, kindly have a look.
Why have they re-examined you?
My lord, I cannot hear, my lord. I went to the medical.
Not like this, not like this.
I have filed affidavit, my lord.
So show us from your affidavit.
Lordship, that is the original readable copy.
We don't need it.
Lordship,
If
lordship.
you have brought it on
Lordship,
record, we-
yes, I filed my affidavit, my lord, on 17/3/25. Arota affidavit is simple.
17/3.
My lord.
Noyan Das. Filed
Yes.
by Noyan Das.
Yes, my lord.
Yes, we have it.
It Arota simple affidavit.
17/3, GMC.
My lord.
Yes.
Examine the documents along with the unique disability I have annexed, my lord. Yes, my lord. There also, they have found, my lord,
They have found what?
I'm disabled person, my lord. The tablet, it will be safe. ATP, it will be safe. 40% disabled.
Why have you submitted yourself to the examination?
My lord, because my lord, my ear was problem, my lord, as on day.
You claim to be a person with benchmark disability.
My lord.
You are holding an ID card. You
ID
are
card
holding
both
some
state and central.
certificate.
Yes, ma'am.
All right. Now you apply.
Yes, my lord.
Then they subject you to further test.
My lord.
You don't want to go for, you are agreed on your ground is that this is our certificate.
No, that has been done, my lord.
That has been done.
Done. Then, my lord, that has been done and my result was not declared what happened to me, my lord. That's why your lordship last order, lordship was pleased to ask the authority to show us the records, then to make argument, my lord. So they did not produce, my lord, might have come now only. Records, Anissa.
What is the date of the order?
Last order, my lord, lordship kindly. This previous order.
The previous order is
Date to go.
is 9/6/25 passed in your writ petition.
My lord, lordship has passed in the common, my lord. First.
Yes, Mr. Counsel.
Lordship, as per the last order, Lordship, we have given the reports to the petitioners council, Lordship. They have checked it, Lordship. There was a direction that they may check the reports in my presence. So few of them have checked, Lordship, but today, Lordship, I can give him, Lordship, to check.
You check up.
Yes.
I'll check it up and
If they're if they're found to be within the benchmark disability.
Yes, Lordship.
Then their cases can be considered.
Yes, Lordship.
All right.
My lord, there will be two specs, my lord.
Huh?
One has to be, my lord, the criteria, how they have followed, re-verifications they have done.
That grievance will arise only when you are found to be
Yes,
eligible.
Yes, yes.
Not
I'll-
within the benchmark.
Yes,
Yes, Lordship.
I'm
If-
within the benchmark.
If you are within the benchmark, are you aggrieved that what criteria has been followed?
No, my lord, my result, my lord, I do not know now also, my lord.
Lordship, I'll. At 1 p.m.
Hey, 1 PM, my Mohanok dekhai diye. Item number, my lord, 5, 6, 7, 8, 9, and 18.
Yeah, you go through the record.
Yes.
Yes, yes. এখানে আছে, list তো আছে। Over there. We'll see it and also pick some other day. Then we'll address, my lord, what to do. If possible, let them file affidavit, my lord, in case. my
What
lord.
affidavit? Then they'll let them file affidavit why the records are to be
No, my
examined by
lord.
you.
It's short.
No, what we want to know is there is already a coordinate bench.
That I'm not against that, my lord.
If you're not
My
against-
case is, my lord,
The core issue in the matter is once you are given a certificate,
my lord.
is there a necessity for the, is there any requirement for the department to go for a fresh inquiry? fresh verification.
My lord.
So this was notified earlier by way of an OM.
Yes,
Well,
Lordship.
That was upheld.
Upheld by the single bench,
Just
my
saying
lord,
the
has
OM
filed.
Review.
may not be, I do not know whether it is here or there, but the OM contains re-evaluation,
Yes, Lordship.
which is also a feature in the notification.
My lord.
So once if it is upheld by a coordinate bench, is there a reason for us not to disagree?
We are not challenging up to that, my lord. I
Now,
agree with
Lordship, an
that.
appeal is pending. Because
So
the
appeal,
review,
is there any stay in the judgment?
no, Lordship.
The
Appeal-
condemnation part is.
Condemnation, they have.
Maybe, but
Yes.
there is no stay.
No, Lordship, nothing. It is
Then-
fixed, the,
the government has took time to.
Lordship, we will find.
Whatever it may be, what we are asking you, once there is a judgment of this court on the similar issue, unless you tell us that no, factually, this judgment is different, is cannot be applied for, we see no reason not to apply the judgment. We'll apply the judgment, close your petitions, you go in appeal. Unless you say that no,
9 December, my lord.
9 January.
9 January, it hasn't. But,
Fixed.
but, my lord, in,
and so far as Mr. Borbuya is concerned, you look into the records and then come and address the court.
My lord.
but, my lord, subsequent, they have filed the affidavit in that case, my lord. They have said that the, as the central government has issued the OM, my lord, the source of power they disclose, as the central government issued, so we, in the same line, we have issued, my lord.
That OM has been upheld.
But, my lord, subsequently, by law, the recruitment authority, my lord, they are saying we are not following that OM. We are following OM in, my lord, 2019.
Oh,
which was,
whichever OM they are following, the question is whether their right to for re-verification has been
State
curtailed
by any court.
by the court. Court has upheld it, saying that yes, it is possible. You can do it.
but even then, my lord, even then, my
And you filed a review, which was also dismissed.
yes, my lord. Yeah. But, my lord, the
So
subsequent,
now until the appellate court interferes with,
yes,
it is to be followed. It's binding,
yes, my lord, but, my lord,
unless you distinguish
Yes,
on
ma'am.
facts.
yes, my lord, my lord, the OM, my lord, this issued by the central government, issued by the OM, my lord, that taking into note, my lord, the apex court now the passed a judgment, my lord, saying that once you, my lord, allowed to participate in the selection process, then you cannot exclude any PWD. In, my lord, that judgment
It is the appeal also.
in the, my lord, suo moto, there are 7 cases were taken up altogether. Taking it at the OM, very, the,
Where it is urged before the coordinate bench.
my,
Did you urge these cases before the coordinate bench?
Yes.
in review, my lord, when I asked this point, my lord, they said, nah, this is the subsequent, so in review jurisdiction,
Where is the judgment of the coordinate bench?
Lordship. It's there, Lordship.
Give us the at least.
Review number 139 of 2024. One of the review numbers.
Review
139. नहीं अभी नहीं आते 139 of 2024.
139 of 24.
Yes, Lordship.
Oh, like you disposed of on which days?
Lordship disposed on 22nd of September 2025. And now, Lordship, they have filed an appeal. And the appeal, there is a delay in the appeal. So, Lordship, we have said that we will file objection to that delay, condonation of delay petition. And the Honorable Division Bench has fixed those matters, those appeal, in the month of January 2009. 2000.
A2 the open meeting. A2 line. WPC 3013/24 12 A2 log 12/6/24. Please log it.
And also, my lord, in that case, then also the interpretation, the ordinance bench my lord, was not inclined to give the interpretation of section 34 and rule 14, 11(4), my lord. The rights of the my lord under the RPWD Act, that was not considered. In re-judgment, I have my lord, copy my lord.
Hmm?
In re-judgment, I have,
What judgment?
which I have placed before the, in review, yeah, I have the copy. There, Apex Court held, there shall not be any distinction between PWD and PWBD. Once they have permitted to allow the participate in the selection process. And held that the discrimination on the ground of disability merit is a fundamental right, my lord. Held. And any indirect discrimination is not permissible. It was held.
Where is the advertisement here?
Advertisement.
Which advertisement you have participated?
2025 3 2020.
Where does one
22.
find it? Where does one find it?
Advertisement. That is page 38. Twenty-five 3 2022. But the OM, my lord, it was issued after this advertisement, my lord. Therefore, it's not applicable. Your lordship.
Yes. Where is that judgment?
In this.
Where is it?
My
Yes. Which paragraph?
Lord, there are so many cases that deals with, my lord, rules as well as my lord. The crux of the issue was, my lord, in this case, my lord, my lord, paragraph 31. 31, 32, my lord. May I first read, my lord? The present sets of case arises important issues that touches upon the umbrella of rights in respect of the differently able persons or PWD who have been afforded special protection under the law. More particularly in the main question that needs to be addressed relates to the suitability of visually impaired persons qualified with a degree in law to be appointed as judicial officers, apart from alleged issues and ancillary principles as to the application of the equality doctrine read with the principle reasonable accommodation as has been recognized and specifically provided for in the Arbitrary Act. this court consciously uses the word suitability as against eligibility, as it is a matter of fact that once a person completes a degree in law and acquires the other required educational qualifications as stipulated for appointment as a judicial officer, she is eligible for appointment to the said post. However, what has been raised here relates to the validity of the rules that touches upon the suitability of the candidates.
This is the validity of the rules.
No, my lord. Also, my lord. Then there are other, my lord. Then section 32, my lord. The crux of the issue in the cases, therefore, is on the one hand, the validity of the rules that bar visually impaired persons from participating in the selection of the judiciary, both directly and indirectly. And on the other hand, the non-selection of candidates where they were permitted.
What is under consideration here?
My lord,
This is the validity of the Delhi judicial rules, service rules.
other issue also there, my lord. The 32, my lord, can you see? On the other hand, my lord, the non-selection of candidates where they were permitted to participate to the vacant post under the unreserved category of physically handicapped quota for the post of civil judge, junior judicial entry level, my lord.
This is with regard to the rules.
Not rule, my lord. There are so many cases, my lord. This, my lord, kindly see, my lord.
Have you read the judgment?
Yes, I have.
You have read?
Yes.
So please explain.
Yes, my lord. There are so many, my lord. Paragraph 7. This was one of the repetition was
In response to your contention that once persons apply
Yes.
as persons with disability
Yes.
or benchmark disability,
Yes.
and subsequently after reassessment it is found that he is a person with disability but not with benchmark disability, he cannot be prevented.
Yes.
That's your case.
That has been clarified. here.
Yes, please show us.
Paragraph 7, my lord, kindly see. Paragraph 7. Challenge is to the order dated so and so passed by the High Court of Madhya Pradesh in Georgia repetition so and so. The said petition was filed by the appellant to set aside the notification dated as far as it relates to the non-selection of the applicant on the vacant post of physically handicapped quota under the unreserved category of the post of civil junior division entry level, and direct to the responsibilities to grant appointment to the appellant on the civil post junior division entry level under physically handicapped candidate under the unreserved category along
Where
with
is the notification
all
produced?
My lord.
What does the notification say?
No, result. He was not selected. So though he has party.
This notification, you are referring to para 7. There is a notification whose interference is sought for.
Yes, my lord.
What does the notification say?
Para 22, my lord, kindly see. Para 22, that details, my lord. 22 to 24, then. May I read? Para 22, details here, my lord. Para 24.
This is on a different issue. Doesn't refer to the notification.
But section 34, my lord, reservation policy.
You're referring to paragraph 22.
22 to 24, my lord.
You read para 22.
According to the appellant, he is a person with disability having 40% permanent low vision. In his grievance, despite securing higher aggregate marks, written exhaustion in the interview, then two other selected candidates in the physically handicapped category, the appellant was not selected for recruitment to the post of joint master. Since the interview he secured slightly lower qualifying marks, according to him, the requisite relaxation as mandated under the Arbitral Act were not applied, leading to the carrying forward to the vacant seats for the person with disability year after year, denying the appellant his rightful selection and also defeating the purpose of the Arbitral Act 2016. Therefore, he preferred assigning the final result rated so and so. This is the result, the notification result of the government Madhya Pradesh so and so, insofar as it relates to his non-selection in the vacant post under the unreserved category physical handicap quota, so and so. The High Court dismissed the petition by judgment so and so. High Court held, my lord, that he is not entitled to the benefit of the section 34. Then here is in submission, my lord. Section 34.
You are referring to para 22. We are asking you to read para 22. You tell us what you have understood from para 22. If you think some other paragraphs are relevant, you take us.
Yes.
From para 22,
yes,
it doesn't reflect what the High Court has held and how it has interfered. This para 22 says person getting more marks.
Yes.
In the physical handicap category has been selected over the petitioner.
Yes, though he was not, my lord. Then come to the relaxation, my lord. Relaxation that the cutoff relaxation of the in marks, my lord, which was given in the OM, my lord.
Your case is not that. Your case is that the subsequent medical evaluation in terms of the notification, whereby you have been declared to be a person below benchmark disability, is not permissible. That is your case.
Yes, but my lord, persons with PWBD and PWD is the same. That was held, my lord.
Where?
My lord.
That is what we have been asking you for 15 minutes.
Yes.
You keep on saying you have read the judgment. We understand that you have not read the judgment. Please read it properly.
I my lord.
And then address the court.
My lord.
Have you gone through the judgments?
Yes, my lord.
No.
Kindly see, my lord. My lord, paragraph 67 and 67. What has been held, my lord? The overall analysis would demonstrate that a rights-based approach necessitates that PWD must not face any discretion in their pursuit of judicial purposes. Instead, there must be affirmative action on the state to provide an inclusive framework. Now it is high time that we view the right against disability-based discrimination as recognized in the Arbitral Act of the same stature as a fundamental right, thereby ensuring that no candidate is denied consideration solely on account of their disability. Further, as extensively discussed, the principle of reasonable accommodation as enshrined in the international conventions, established jurisprudence, and the RPW 2016 mandate that accommodation be provided to PWDs as a prerequisite to assessing their eligibility. In light of the above, any indirect discrimination that results in the exclusion of PWDs, whether through rigid cutoff.
You are not addressing the issue. Either you don't know or you don't want to address. We are not sure which of the two. You are before the court. You claim to be who? Do you claim to be a person with disability or a person with benchmark disability?
Oui. Because, my lord.
Who are you? Who are you representing?
Because they have.
No. Who are you representing? Your client.
Yes.
Is he a person with disability or is he a person with benchmark disability?
They have given the status that we are.
You have accepted it.
PWBD.
You have accepted it for all along.
My lord.
You have the ID card.
Yes.
What does it say?
ID card says 40% PWBD.
PWBD.
Yes.
Why we accepted it? When it is your argument to say that what is sufficient is for you to be a person with disability. That's your argument you're making now.
percentage is, my lord.
But
Percent-
you have that certificate.
Yes, I have that certificate. And
You have applied on the basis of the certificate.
yes, because they have given, my lord.
So
The-
now once you have applied in the category,
Yes.
now you want to turn around and say, no. Mainly because since even if I am below 40%, I have to be given.
Yes,
That is a claim you could have made earlier.
because in the selection, the merit, after the selection was over, my lord. The merit is to be, my lord, yeah, my lord. And my lord,
I have given you sufficient
my lord,
opportunity.
and
You are wasting the judicial time.
My lord, kindly one aspect, my lord. The in one judgment, my lord, may I place the UDID card, what
You
has been
first
given?
go through the judgment and tell us.
Yes, I'll.
You are placing a judgment without reading the judgment. That is the least we can expect of a council.
Yes, I'll go through.
List after 1 week. Enabling the council for the parties to apprise the court of the judgments in which they seek to rely in support of their contentions. So, you are producing reports for Mr.
J.I. Bhargava, Lordship Council.
Borbuya.
My lord, instead of, my lord, 1 week, my lord, some more time be granted, my lord. If there is a lordship thing, there may be any bearing on my case relating to
You
the
are-
appeal.
After 1 week, you tell us, examine the records and tell us.
After a week.
You are looking into the records.
Yes.
Then you tell us.
Only my learned friend, my lord, makes it available today itself.
Yes, yes.
Ajay banai diya.
First page. Yes.
Lordship fix the date, my lord. By that time, I'll be ready, my lord.
11
December.
December, lordship.
That will be listed again on 11 December enabling. I got it. Yes.
Lordship.
Obliged.
Item number 100 of the hearing list. Hundred one.
The matter will be taken up at 2 p.m. Lordship.
My lord, the day after tomorrow may be taken.
Day after tomorrow.
Oh, more. On Tuesday, my lord.
Tuesday, all right, Tuesday.
Obliged, Lordship.
Tuesday.
Hello.
What is it? No order, call up on Tuesday.
102. Item 102.
What is it?